Okay, next is section 5, information about legal services. This section deals with providing information about the lawyer's services, because essentially it involves the business of law, because it's all about making money. So solicitation, that means personal contact. When you contact someone directly, it's in-person contact. So a lawyer may not initiate direct contact, whether by, in person, if you're at the scene of an accident, or by telephone. You can't call someone, a prospective client, when a significant motive for doing so is the lawyer's pecuniary gain. Well, that means that you can go and initiate conversations with someone when you're planning to take their case pro bono. So you may not call or personally contact a prospective client unless you're doing it for no money. The rationale is based on the potential for abuse when a lawyer makes direct contact with someone known to need legal services. The rule does not apply if the person contacted is another lawyer, a former client, a close friend, or a family member. The reason is there is a far less likelihood the lawyer would engage in abusive practices against someone with whom the lawyer has a prior relationship. I mean, think about it. You can go ahead and contact anyone you've had a prior relationship with, a former client, close friend, or a family member. You've obviously had a prior relationship with them. So if, like, my brother gets arrested for a DUI, I can, walk up to him and go, hey, John, I'll take care of this, man. And I'm going to charge you too, because obviously I've got to get money or else it wouldn't violate the rule. But yeah, I could go up to my brother and say that. I go, hey, I'll take on your case for cost. You're allowed to do that because him and I have a prior relationship, simple as that. Now in California, there are some presumed violations. So a presumed violation occurs when a communication is delivered to a potential client who is in a physical, emotional, or mental state that she should not be expected to exercise reasonable judgment as the retention of counsel. So there was a fact pattern where a woman just found out her and her husband were going to get divorced and she was in an emotional wreck. That's a presumed violation in California. Also, if somebody's in a body cast, you can't talk to them about legal services. There's a presumed violation. So it's also unlawful to solicit a person at the scene of an accident, someone who's en route to the hospital, or an emergency room. So essentially, you can't just walk by the scene of an accident and flick your business card there, or ride in the ambulance with an accident victim trying to get him to sign a retainer agreement. You can't do that. Okay, runners and cappers. What are runners and cappers? They're just somebody you pay to do the dirty work for you. They're just acting as an agent for the attorney. A lawyer is also prohibited from using a runner or capper to solicit business. A runner or capper is any person acting as an agent for the attorney. So a lawyer cannot use another person to do what the lawyer herself cannot do. This is a true story once. There's this, and they were in Orange County, and it might still be going on. But when I lived in Orange County, there was a law firm, or there was a lawyer there, who would pay cab drivers to wait outside the Newport Beach police station for DUI victims, or DUI people who've been arrested for a DUI. When they get released OR on their own recognizance and they sober up, they come out of the jail. Well, generally when they come out of the jail, they don't have any money or anything like that, so the cab would offer to take them home for free. And the hitch being going, hey, don't worry, I'll give you a ride home. The ride's taken care of by this attorney. Here's his card. You see, the lawyer's soliciting in person somebody who's in need of legal services, obviously doing it for a financial gain. There's no past relationship, and he's using an agent to do so. So in that situation I just gave you, they're making direct contact with a person in need of legal services and using a runner or capper or an agent to do the dirty work for the lawyer. You may not do that. So that's what solicitation is. Solicitation is direct contact with a prospective client. Phone call, approaching the client at an accident scene. That's what solicitation is. Now, advertising, on the other hand, is permitted. You're allowed to advertise. It's under the First Amendment. Remember in constitutional law when we covered commercial speech? This is commercial speech. And commercial speech gets intermediate scrutiny, and it can't be false or misleading. Lo and behold, what is our rule? Can't be false or misleading. So let's go through advertisement. The Supreme Court has found that under the First Amendment, lawyer advertisement is protected commercial speech. Therefore, a lawyer may advertise his services, provided the communication is not false or misleading. You just can't lie to people, simple as that. An advertisement may be misleading if it contains an unverified claim or comparison. Okay. Moreover, every advertisement must include the name and address of the lawyer responsible for its content and must state that it is an advertisement and include the words advertising material. So if you send an envelope out, the envelope must state advertising material on the outside of the envelope, and the comments suggest that it be at least 11 or 12-point font and in red lettering. So that's why I think it's 12-point font and must be in red lettering, or it should be in red lettering. So if you comply with the comments, you can't be in violation of the rules. So what should you do? You should put it in red lettering, and you should make it at least 12-point font. And it must be on the outside of the envelope, and it must also be at the beginning and the end of the advertisement, just so the person is aware that this is an advertisement for legal services. So in short, a lawyer may send truthful, non-deceptive letters to people known to face a specific legal problem. One of the things you ever find, if any of you have ever known someone, or if yourself have ever gotten a DUI, 30 days after the DUI, mailbox will be littered with letters from attorneys soliciting, well, advertising their hey, we'll take care of you for this DUI. So in California, the rules are pretty much the same, except California prohibits advertisements that contain a guarantee or prediction or state no fee without recovery unless it also discloses whether or not the client will be liable for costs. So similarly, an unsubstantiated comparison of the lawyer's fees with the fees of another lawyer may be misleading if presented with such specificity as to would lead a reasonable person to conclude that the comparison can be substantiated. So essentially, you can't say what other lawyers charge and what you're going to charge if it's not verified, if it's not been substantiated, if there's no real ground for that statement. You have to have some kind of basis for making it. Also in California, communication is presumed to be false or misleading if it's delivered to a potential client who is in the hospital or is suffering from physical or mental distress. We actually covered that in solicitation. It also applies to advertisements. Okay, so you're allowed to advertise. It can't be false or misleading. It must have the words advertising material on it. Simple as that. Okay, specialization. Now, you can't say you're specialized in a certain area of law unless, of course, you've been certified by an accredited board. An accredited board is one approved by the state bar or the ABA. And you must also put the name of the certifying organization in the communication. However, what you can do is you may list the area of practice that you've limited. You may list the area of law that you've limited your practice to. So you could send out an advertisement that says, hey, I am a personal injury attorney. You can't say you're a certified specialist in personal injury law, but you could say that I'm limiting my practice and only practicing personal injury law. So a lawyer may send a professional announcement listing her area of practice as personal injury so long as the announcement complies with the rules for advertisements. It can't be false or misleading, and it must state the word advertising material on it. And finally, recommending a lawyer's services. A lawyer may not give anything of value to a person for recommending the lawyer's services. In short, a lawyer is not permitted to pay someone for referring them. Under the ABA, don't forget, no referral fees under the ABA. California does allow it. So in California, an attorney may give a gift to a person who has recommended the attorney's services, so long as the gift was not offered in consideration of any promise that referrals will be made in the future. So in California, you can give a gift, it's okay. It just can't be for any future promises of, hey, you're gonna start referring people to me from now on? Can't do that. That's what we want to prevent against. So, distinguish between solicitation and advertisement. Solicitation is personal contact by phone at the scene of an accident, whereas advertisement is when the lawyer sends out information to the general public, whether it's a television commercial, an internet ad, or a billboard, or sending out mailers. And that wraps up section 5 for information about legal services.